Hello guys, I'm Nadin Anjani. I will explain about the customary rights that occur in the Tiakur village of Southwest Maluku. Disputes relate to land ownership and utilization often arise in the community, and this problem is getting worse from year to year, spreading almost throughout Indonesia, including both urban and rural areas. The rights is hak ulayat, which is a term introduced in the Indonesian Constitution. Customary law literature with different destination and or names in each region. Customary law literature with different destination and names in each region. Customary law in is the highest control in a customary law area because it is the common land of certain indigenous people. Karta Saputra 1998. The definition of Ulayat rights according to G. Kartasaputra in France in his book Land Law, UUPA guarantee states that Ulayat rights are the highest rights to land owned by a legal community or village and tribe to ensure orderly utilization and use of land. Santoso 2017. Thus, land disputes in community often occurs where every year it increases and occurs in almost all regions in the territory of Indonesia, both in urban and rural areas, as happened in Tiakur community, the capital of Southwest Maluku Regency, Maluku Province in Supreme Court Decision number 1839 K or PDT or 2019, where there was a customary land rights dispute between Fritz Hosea Gaspar Pure as the plaintiff against Domingos Isaac A. Lico and other of CO defendants, where the plaintiff sued the defendants for the release of customary land rights in according with the letter of release of land rights to the Regency government Southwest Maluku with the dispute object covering an area of 30,190 ha or 350 hectare are, and the control and use of the defendants of the dispute object since 2008 until 2017 located in West Moa Subdistrict, Southwest Maluku Regency because the object was inherited from the plaintiff's ancestor named Lewan Rupruk Deli Wewar Lai Wewar, who was a marna or nobleman from West Moa called Sauna, who has the owner of the West Moa Betuanan land. Against the law for releasing and rights without consultation with the plaintiff, who in this case in the heir to the customary land. Therefore, the plaintiff sued the defendants to the Saumlaki District Court against the lawsuit and handed down decision, which state rejecting the defendant's exception that the plaintiff is the legal owner of the dispute object and stating that the action of the defendants in the form of granting or releasing and rights without rights and control and use of the dispute object by the defendants are unlawful. Then the decision was overturned by the Ambon High Court, received an appeal from the appellant, who was originally the defendant, which stated that it cancelled The decision of the Samlaki district court request in the appeal level. Based on the appeal decision, that Apple, who was original the plaintiff, filed a cassation against the Apple to the Supreme Court, which in the ruling, this cassation decision stated the cassation request was rejected. Based on the background described above, in order to understand the process of the appeal process, it is necessary to examine the consideration process of the panel of judges in deciding the case and the juridical implications in the implementation of the verdict. The author will conduct research with the following objectives. Implementation of the decision, the author will conduct research with the title Settlement of the Tiakur Land Dispute, Capital of Southwest Maluku Regency, Maluku Province. The facts in this case are that the plaintiff is a descendant or legal heir of the late ancestor Lewan Roprupdeli Wewarlai Wewewar, who during his lifetime was a marna or noble of Westmoa known as Sauna, who was the owner of the Westmoa Petuanan land, which include the former Negri Toinaman Petuanan. That because the plaintiff is the legitimate descendant or heir of the late ancestor who was the owner of the West Moa Petuanan land. The plaintiff filed a lawsuit to defend his property rights in the form of West Moa Petuanan land, which include the former Petuanan land of Negritoinaman. However, at the appeal stage, the plaintiff was unable to prove that the plaintiff was a direct descendant of the late ancestor, and this was denied by the defendants that the plaintiff's ancestors were not descendants of noblemen or mama. Meanwhile, the defendants have valid evidence of ownership of the customary land, namely the statement of privilege of land rights. Thank you, guys.